In my view, the contract or the standard contracts that are floating about and used in the industry have served the parties reasonably well for some time. You can have arguments about some of the individual provisions within the contract. The problem occurs with the conduct of the parties on site and the expectations that each party has in the contract. And I always remember one of my contract lecturers always stating, you'll never have an argument about the contract, it's the party's understanding of the contract. And what you often get in this situation is an expectation from the consumer about, say, the level of quality and the expectation of the builder. And most of the arguments relate to the standards. The builder is required to work within a complex set of codes and Australian standards. The homeowner has a view about, for example, how the paintwork should look. The builder believes they have done a reasonable and satisfactory job, or the contractor has. Parties enter into a dispute about that. There's nothing in the contract about that. Litigation arises. So then we have an argument about whether or not the paintwork is within Australian standard. So if it can't be resolved through the conciliatory mechanism, and usually the homeowner wants the whole house repainted, the builder says, I'm prepared to paint one wall. If it's not settled, we all run off the VCAT. We'll all stand and look at the wall and determine whether or not it is within Australian standards. We will engage, or the homeowner will engage a building expert, and the builder will engage a building expert, and neither of the two shall meet. And we'll continue to have the argument until the parties or the judicial officer, the tribunal member, decides whether or not it complies with Australian standard. That's where the majority of the problems are. In some cases, the paintwork is blatantly, obviously poor, and the insurer in those cases, or the VBA, should have the power to direct the builder to attend to rectification.